process in a timely manner, um, and that any matters were escalated at the right time. So what we started doing really was looking at our CP plans from 6 months onwards and reviewing those on a monthly basis. It was supported by our conference chair team manager, our kinship team manager, and our family group conference team manager, and really it allowed us to look to ensure that solutions were identified, blockers were removed, but also that solution focused discussions were held to support team managers in order to progress the plans in their group supervisions. What that also allowed us then to do is think about escalation to our legal gateway panel at the earliest opportunity. We acknowledge that this required a high level of support and buy-in from colleagues, but what we were able to see quite quickly is that by doing this, we were able to safely reduce the number of CP plans in the service by about 33% in a year period. As I said, the approach also saw us escalate matters of concern to our legal gateway panel consistently at the earliest opportunity. It enabled us to provide families those opportunities to both engage in the support that's being offered, but also have the opportunity to access independent legal advice and improve situations for children. Our legal gateway panel is chaired by myself or the group manager for family safeguarding, and it's very much a multi-agency decision-making panel. So along with the people who sit on the CP review forum, we've also got our parenting assessment team manager. We've also got colleagues from our Edge of Care service. Um, and what we're looking at there is people are coming, social workers and team managers, being really clear on what they're concerned about, where they think there's a challenge, and what their plan is. Clearly, at that point, then we get some legal advice, and we either move things into pre-proceedings, or if we need to, directly to care proceedings if the concerns are so great. What we do is when we move into pre-proceedings, parents and carers are really clear, and we've been really consistent around this over the last 2 to 3 years. It's not a tick box exercise that previously it may have been seen, and it's the next step before you move into court. We use it as a really proactive mechanism to focus on those specific issues that have led us to cross threshold, but then take a view that we can safely manage in pre-proceedings. So our letters, our meetings, and our support plans really focus on those rather than being a repetition of a CP plan, really focusing on what are the key drivers and those key challenges that are causing us all to think that long-term children may not be able to remain in families, or what needs to change so that children can remain in families. Clearly, taking this approach carries a number of benefits, but it's not without risk. Firstly, by escalating earlier, there is a chance that issues are not resolved, and we may see an increase in public law applications and potentially our care numbers. However, we feel that the opportunity to improve the circumstances for young people and children in their family unit far outweighs those risks. And we've consistently seen, since we've adopted the approach, an increase in diversion away from care proceedings, sometimes up towards 70–75%. It's also then backed up through our replan data, both child protection plans coming back within 12 and 24 months are incredibly low, running between 5 and 7%. And again, that shows us that the approach we've taken, along with the approach that we have in family safeguarding of our adult practitioners working alongside our social workers, has a real positive impact for children and families. Our court progression officer is integral to the approach through her consistent tracking of pre-proceedings meetings, plans and timescales. Again, this allows us to review timely the matters in our legal gateway panel and identify any drift with the group manager for family safeguarding to take forward with the operational teams. Our offer around pre-proceedings includes independently commissioned advocacy for all parents who enter into pre-proceedings to provide that additional support to them during that period. And those advocates can stay involved should we de-escalate or escalate to provide some consistency. One of the things that we did see when we were doing a deep dive on our pre-proceedings work is often solicitors would come to the initial pre-proceedings meetings, but families would tell us they either have contact with a legal assistant or different colleagues from those legal firms in future meetings, which impacts on their ability to understand what's being discussed, how plans are being progressed. So the use of those independent advocates both supports parent carers, but also supports those discussions in pre-proceedings meetings. And again, as the last two boxes have identified, we've got that consistent offer of facilitated family conversations or family group conferences and the connectivity with our kinship assessment team so that we can really identify connected people or networks who can support families, either to support the plans going forward or where we need to safely place children within their extended or kinship arrangements. Next slide, please. And I think that's hands over to Naomi.
So Paul presented what he's just presented to us at one of our peer review sessions, and I was really interested to bring some of that information back to Central London colleagues, and we discussed within our steering group what aspects of the model some of the local authorities might want to consider to include as part of the work that they're doing around care proceedings and pre-proceedings. I think one of the big difficulties in Central London is that we're 12 local authorities that are made up of very different demographics, very different challenges, and also very different volumes of cases coming through. What we were able to trial across the region, which has been really great, is the parental advocacy. And I guess that links in really nicely with some of the kind of social care reform recommendations around kind of bringing in parent advocacy at a much earlier stage. And for some of the local authorities that we trialed, the parent advocacy, it has worked really well. And then for some of the other local authorities, it's been quite difficult for them to get parent interest and agreement, because I think that it's really about building that culture of parent advocacy. And I think that's something that you and I talked about quite a lot, didn't we, Paul, is that it took quite a while to embed that offer as something that parents felt comfortable to take it up. Would you say that was fair?
Yeah, absolutely. I think initially we trialled it as a pilot exercise, and we got lots of feedback coming back from parents, but also from the advocates and the advocacy companies, as well as social workers, team managers, and we were able to then iron out some of those challenges. So it became a far more embedded approach, really, as part of our pre-proceedings work.
Yeah, so we're at the beginning of that for Central London, I would say. And as I said before, I think some of the local authorities felt that the kind of intensity of the oversight of the model in Telford would have taken up too much of their time in terms of their high volume of cases. So they'd be kind of potentially sitting in these panels all week. And then I would say that a lot of the Central London local authorities felt that actually they were embedding aspects of the Telford model in their pre-proceedings practice and processes already, and certainly recognised aspects of them in the work that they were already doing, which is also really positive, I think, to kind of, we can have quite a London-centric view in Central London. And actually, it's nice to know that we're learning from other colleagues across the country, but also doing similar practice in certain aspects. We could be a bit all about London. So it was really great to work with Paul on that and kind of learn from Telford, but also recognise some of the good work that's happening in Central London.
I think I'd add to that, Naomi, given where we sit in the region, but also nationally, it was really good to come and talk to you guys in London. And again, I think the president referenced this around inventing the wheel. We haven't reinvented the wheel. It's just what works for us in Telford. It allows us to be agile and respond to our evolving needs. So it was really, again, reassuring, but also informative to think about what's going on in some of the London boroughs, which will be a very different demographic and have different volume maybe than we have in Telford. So yeah, absolutely, we recognised the benefits of connecting with you guys.
I think it's next slide, but I'm not sure it's my slide.
I think it's Paul next.
No, it's me. So I think for us in Telford, why it works, as I've touched upon, it allows us to be really agile and really responsive, and but also proactive in terms of what we're looking to do for our families. What we've been able to build upon really is seeing us reduce the number of public law applications, but also reduce the duration of those applications. So currently our average is about 31 weeks, and that is reducing consistently, which is really positive. What's also assisted with this is that we've got a really positive working relationship with our local CAFCAS team. and we hold quarterly development sessions to ensure that social workers and guardians can develop their working relationships and share best practice. I also meet with my equivalent from CAFCAS on a monthly basis, and we look at all of our cases over 12 weeks, so there's more tracking there. And again, that allows us to ensure that proceedings remain on track and that any issues or blockers can be resolved swiftly, and we can understand and learn from anything that goes over 26 weeks. And I guess we're lucky in that sense. We've really worked on that relationship and have seen the fruits of our labour. I think what I'd also say is we've got a really active DFJ, and LFJ being in Wolverhampton, Telford and Shropshire. So again, we're able to learn in Telford from the work that other local authorities are doing in our area, and again share some of that learning. So we've got a really collaborative approach, recognising that again in our LFJB area we've got very different demographics and needs sometimes. I think the other thing around that is that as a Wave 1 family network pilot area, we've been able to align that pilot to our pre-proceedings offer and really focus on the practical support we're offering to families, their extended families and networks to ensure that they can provide that long-term sustainable support. As we move towards the end of that pilot, what we're really seeing is that often people require very little financial support, but actually what they do need is somebody just to pull them together to think about what practical steps can be taken to really bring that network together and keep them and hold them together. And as I've talked about consistently, really, it's that case tracking. And for us, that court progression officer is absolutely a vital component of the work we do in Telford. She sits across children's services and legal services. So we've really got that consistent and really rapid dialogue between the two areas to ensure that work is being progressed. And again, any challenges are identified. Next slide, please. So Ofsted came back to see us just over 12 months ago. And as you'll see on the screen, from a position of pre-proceedings being an area of development, it was very much seen as an area of strength for us in Telford. And again, these were some of the comments that were taken from our Ofsted report, which we were incredibly proud of. As Naomi's touched upon, for some of the London boroughs, we know it's labour intensive. It requires a huge amount of buy-in and diary commitment from a number of different people. But actually what we found for us in Telford is that by doing that, we've probably alleviated some additional work pressures elsewhere in the system at a later date. So it's something that we'll certainly continuing with. Next slide, please. So what we're doing next, we're reviewing all of our pre-proceedings paperwork, and as part of our Trailblazer activity, we've recommissioned our initial letter before proceedings letter, and we've used our lived experience group in Telford, the Dandelions, to really think about, well, what is in that letter and how is that received and how does that land with families? So for us, that new refresh letter will be going live on the 1st of April, and it really hones in on what it is that we're looking to achieve and how we're trying to support parents, and really reinforcing that pre-proceedings is that mechanism to support rather than just a stepping stone into care proceedings. We're also looking at enhancing the training offer to all staff to develop the skills in working with a PLO. And again, that's been part of our Trailblazer work in Wolverhampton, Shropshire and Telford over the past year. And the training offer to really upskill social workers and feel confident that when they're working with families and going before the court, that they're very much seen as experts. And finally, we're developing our data dashboard. And again, that will allow us then to really track all activity in our PLO arena, and be really smart around what we're doing, and also celebrate our successes, but really drill down and look at areas that still require that oversight and that improvement. And I think I'm handing back over to you, Naomi.
Just before you kick off, Naomi, there's lots of questions coming in, which is great, and we will have some time at the end to deal with those. We started a couple of minutes. This started the session a couple of minutes late, so depending on how many questions we get on your section, Naomi, we might stay behind for a couple of minutes and eat into that lunch break. But yes, we should have time to get to all your questions, and please continue to send them in. So over to you, Naomi.
Thanks. So I wanted to talk a little bit about the kind of tools that we've developed as part of the Central London Trailblazer project around kind of supporting practitioners to improve pre-proceedings practice in the 12 Central London local authorities. So I have led on developing a good practice guide. It says here a chatbot, but actually it's what's known in the business as an AI assistant. So I'm going to hopefully show you a bit about how that works. It'll be open to the public for any practitioner to use, and it's really thinking about how we can pull together all the best practice information in one place so that practitioners have a really easy way of getting that information at their fingertips. We also developed a pre-proceedings animation explainer for parents, which we're also hoping to debut here. I don't know how much time we'll have to show of that, as well as all the questions that everybody has for Paul, but we'll see. And then, as I mentioned before, we piloted advocacy. So that's offering a parent an advocate, not a lawyer, because I just saw that was one of the questions in the chat. So it's a parent advocate to support them through the pre-proceedings process. And that's what they do in Telford. And that's what we've modelled our offer on, which has been going really, really well. And we're just awaiting the feedback from those 4 Central London local authorities. So next slide, and I will give a bit more about the practice guide, please. So here it is. So basically we had an initial intention in Central London to develop a practice guide, kind of bringing together things that already existed in Central London local authorities, as well as kind of developing and collating some of that information. We kind of initially envisaged it would be a handout, and then we remembered it was 2025, and actually who looks at paper? So we worked really hard at creating a website that was somewhat, I guess, modelled on a kind of TRIEX policies and procedures a model, but a little bit more easy on the eye. And then we kind of further developed that because in doing this piece of work, I realised how many incredible resources there were out there that I had never had time as a social worker and a social work manager and a chair to ever read properly. And I figured that that was very much the experience of most practitioners out there. So we thought that we would further develop the idea and build an AI assistant so that you could essentially ask the AI assistant a question, and it would pull information from the practice guide website, but any linked information. So it pulls from the Public Law Working Group report in 2021. It pulls from a lot of really incredible publicly available research and practice research. So it's really, hopefully, giving practitioners the information that they need. So I'm hoping that we can debut it. Oh, next slide, please. I give the impression that I'm very techie. Okay, so this is the guide. My little robot, are you gonna let us see the guide, robot? There we go, here we go, it's happening. So this is kind of the areas that it covers. It's information for Central London practitioners, but actually all the information would be kind of appropriate for England and Wales. It's moving quicker than I can talk. Here is the AI assistant. So we're gonna ask the AI assistant a question and we're gonna see the information that it gives us. What question are you gonna ask? How many hearings are there during a typical care proceedings? It's thinking, which is great. Spends quite a lot of time thinking. Here we go. So it's given us an answer, given us kind of a bit of a summary, and it's also really important, and it says at the bottom, AI generated content might be wrong. Please verify and double check answers. And then also really importantly, and it should say this at the bottom of every answer, you should always discuss any case-related matters with your manager and supervisor, and always check your own local authorities' policies and procedures. Okay, it's going to ask us another question. How can I help an 8-year-old who likes magic understand, oh, it's not very good grammar, understand care proceedings in 5 minutes? Again, thinking very hard here. So this is just to give you a flavour of kind of the creativity that the AI assistant can kind of offer as part of pulling kind of key information from the practice guide and related websites. So yeah, I like this one. I don't know if you've got any guardians listening, but according to the AI assistant, you'd be the guardian wizard if you were describing this to an 8-year-old. And judges, you are like a group of powerful wizards who gather to decide what's best for the child. And it says very nicely here, even though you are young, your thoughts and feelings are very important. The guardian wizard will tell the council what you want and how you feel. It's going to ask one more question. What do I need to consider in a care plan for a 14-year-old girl who is neurodiverse? So what's also really important about this AI assistant is that it should be giving references for the information that it's providing you. So if you'll see here, there'll be a little 1 here, and all the way through the answer, there should be relevant references that then, and I think it will show us soon, at the bottom, you can click through to see where the information has pulled from, and then you can go to that relevant website to actually get more information that can help you as part of your piece of work or your intervention. My robot's much slower than I talk. Let's see, is it going to show us? I feel like there's someone doing something at the bottom. My personal robot. Oh, here we go. Okay, so 3 references to the information shared above, and it will show you where that information came from. So it pulled a lot of information from the CAFCAS guidance for completing a sweat, and also the top tips from the Family Justice Young People Board. And then right at the bottom of that reference, it will give a long website address, which you can then copy and paste into your browser to get the information directly from the source, because I think that's also something we just really want to stress to all users, like I did at the beginning, is that we always want to make sure that there are that you properly verify your answers. And I think it has one more question, which leads us very nicely into our next section, which is our explainer video. So how do I help a parent to understand the care proceedings process? So these are videos that we developed with parents in central London who have experience of care proceedings and pre-proceedings. 2 parents really kindly agreed to narrate the videos, and these videos are also available on YouTube for anybody to access. So we would welcome people using them as a tool to support parents with understanding the process in a bit of an easier way, and they will also be translated into 8 different languages and will be available. So next slide, please, and hopefully we can demo the video.
You may have been informed that the local authority has started pre-proceedings, or PLO, public law outline. This can feel overwhelming, but is designed to work with you to ensure that your child's safety and well-being are being met. Pre-proceedings only begin when the local authority believes that your child may be at risk of significant harm or their needs aren't being met. It's a formal process that gives you a chance to work together to make a positive change and potentially avoid court. You'll receive a letter from the social worker talking about the worries for your child, such as worries about their safety, health, education, or emotional well-being. This letter invites you to a meeting to talk about worries in details and highlight any changes the team believe are needed to support your child. It's important to read this carefully and get legal advice, which the letter should explain in detail. Your lawyer will attend the meeting with you to help you understand what's being discussed and provide support in each step. The letter might ask if there are friends or family members who could help care for your child, as they can sometimes be involved in the process. A social worker will share an assessment of your child's needs and support plan, outlining their worries and steps they would like you to take. You will have a chance to talk through this plan, ask questions, and learn about the support available to help you make these changes. If this meeting hasn't been set up, ask your social worker to arrange it. To gain further insight into your situation, you'll be asked to take part in an assessment. They can look different depending on your circumstances. The people doing these assessments may visit you in your home, or you may meet the social worker in their office. The outcome will inform the decision about what happens next for you and your family. You will have regular follow-up meetings with your social worker to review support being offered, discuss how you're getting on, and address any challenges. These meetings are valuable opportunities for you to show the changes you are making and request additional support if you need it. If you're able to be open and honest with your social worker, everyone can stay focused on your child's safety and well-being. There'll be a final meeting to review everything that happened, including the assessment and the progress with the support plan. If the social work team believes the risk to your child is now less, they may decide to step down the support, working with you on a less formal basis. However, if the social worker is still worried that your child's at risk of harm, they may start court proceedings where a judge will make a decision about your child's safety and living arrangements. It's so important to engage with the pre-proceedings process, work closely with your social worker, and get legal advice when needed. Remember, we are all a team to help achieve a life of safety so your child can live their dreams and achieve anything they want to be.
Great. And just to note that there are closed caption subtitles for that video, and it is available in a number of other languages as well. And both the AI chatbot and the AI assistant, sorry, Naomi, and the pre-proceedings and care proceedings video will be made available to everybody after the session, after the conference today. We've got lots of questions, and we've only got a couple of minutes left before we go to lunch, but we'll try and take a few of these now. So lots of praise for the chatbot, Naomi, sorry, the AI assistant. Paul, we got a fair few questions at the start on the gateway planning meeting.
Okay.
I wonder if you could just go into a little more detail on some of the impacts on delays on issuing proceedings on urgent cases. And also whether there's a lawyer on the panel, or is it agreed with the social workers what the way forward will be for that case?
Yeah, there is a lawyer on the panel, so we have legal assistants on the panel every time it meets, and it meets each Wednesday. So we don't have delay in that sense. And when I talked to her about having an agile process in Telford, if we need to, and if the situation demands it, we can have a legal planning meeting. If children were police protected, for example, on a Monday, we can't wait until a Wednesday lunchtime to review that. So we will have a legal planning meeting so that we can make swift and timely decisions for children outside of that panel, and then matters come into panel then just for ratification, and then they can be tracked from there. So yeah, absolutely.
Okay. We had a lot of questions on the advocacy offer as well.
Okay.
So people are interested in how many parents take up the advocacy offer, who pays for them, and there are a couple of questions as well on how the advocacy interacts with legal advice that parents are offered as well? How do you avoid contradictions? How do parents know what the best option is for them?
Absolutely. So in terms of funding, it's local authority funded. We source the advocates, they're private companies, and they go through our framework. So our brokerage service will identify, we'll put the referral out, and they will come back and say that they can meet need. We're really clear, and we were really clear with the advocacy services at the start when we started commissioning this. It's not their role necessarily it's not their role to offer legal advice, but what we do ensure, we offer 15 hours initially, and that can be extended. So the advocates will often go to meetings with parents at their solicitors' offices. So it's less around the advice, but it's more potentially around interpreting the information in a way that meets parents' needs. We started it really thinking about those parents that have got low cognitive ability, or we may need, have got some cognitive challenges. We've extended that out. We just want to give parents every opportunity to ensure that the support we offer lands correctly, and that they're given every opportunity to understand what we're concerned about, but how we're trying to support them as well. So there's a really, really clear markation really in terms of what the advocates do and then what legal reps offer.
Okay. That's great. And a couple of questions as well on the assessments that you do in pre-proceedings. Are they typically recognised in the courts? Are many of them challenged? And who delivers those? Is it typically social work qualified practitioners, or is it others?
So it's a combination. In terms of who delivers the assessments, yes, our assessments are largely accepted by the courts. For the past 7 or 8 years, we've had a dedicated parenting assessment team that sits out of the main social work teams. It's manned and operated by 2 full-time experienced social workers, and a number of family safeguarding practitioners, all of whom are both parent assess and PAMS trained. That enables us to offer to the courts and to parties when we are in court a level of independence, because they're not case responsible. It is their role to complete those assessments, and those assessments are well received by the courts and other parties. We've extended that offer, so we've also got a number of psychologists and assistant psychologists in the service, both as part of the parenting assessment team and also as part of our wider family safeguarding offer. And again, their assessments are well respected and often accepted by the courts and other parties.
Brilliant. Okay, and I think I'll make this the final question because I'm aware we've overrun slightly. And again, it's for you, Paul. Naomi, all the comments about the chatbot, goodness, assistant are all saying how great it is and can people get hold of it soon. So no questions as such. But Paul, people are interested in your data. How many families you typically support through pre-proceedings, and that's the next question actually. There's a follow-up question on how the case progression officer tracks those pre-proceedings.
Yeah. So typically we're working between sort of 12 and 20 families at any one time. So they're not huge numbers. We recognise that. I think it's a fair proportion of our child protection work. Our child protection numbers we've probably got 158 young people on a CP plan. So it's a proportion that sits underneath that. In terms of the tracking, the court progression officer has her own tracker, so she follows those around. She's co-located in legal services, but also has got a very good presence within family safeguarding, and has those weekly catch-ups and touch points with team managers and social workers to ensure that matters remain on track. And then we'll forward plan in terms of when matters are due back for review in legal gateway panel, and also flag any issues that may arise with the group manager who has that operational oversight of the service, or myself if there's any particular challenges that we need to be aware of.
Brilliant. Okay. I think that's all the time we'll have for questions now then. That was really helpful, Paul. Anybody whose question we didn't get to in the session today, we will be able to write back to you over the course of today and afterwards.
Can I just clarify, Will? Sorry, because I know there were a couple of questions. Just to say, the practice guide and the chatbot AI assistant is available for anybody. It's public, it's a public website, and we'll send that out. Anybody can use it, and it should be information that is appropriate for any practitioner in any local authority in England and Wales. So sorry, I just wanted to doubly clarify that.
Absolutely important point to clarify. Naomi, Paul, thank you very much for your time today. That was really interesting. Thank you, everybody, for your questions. Next session will begin at 1:05 after lunch. That will be another keynote address from Nikki Webster, who is an expert by experience. So hopefully you can join us all for that one. But yeah, thanks for joining, and see you after lunch.